When can schools punish students for unauthorized use of AI? Is the use of AI sufficiently covered by schools' existing academic integrity policies? Jamie, how big of a stink are you willing to make to change a C+ to a B?
A C+ to a B?
C+ to a B.
Like 3 percentage points?
Pretty much.
That's what this is about?
That's what this entire case is about.
Great.
I know, it's an important one.
Yeah, no, this is a good one. So this case is about a student who failed an assignment for the improper use of AI, and that resulted in, let's just say, some light discipline. Anyway, mom and dad, not too happy. They brought a lawsuit against the school to undo that light punishment. And this is AI in education, folks. This is a timely case. So that's what we're going to dive into today.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. Now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Yeah, so today we're covering a very recent case from November of 2024. So imagine working on a project and then being accused of cheating. This case is Harris versus Adams. This is a case involving a student who was punished for using AI to complete a history project. His parents fought back, saying that the punishment violated his rights. But did they have a case? Today, we're going to break down this recent, timely situation that tackles when the use of AI crosses the line into academic dishonesty. I know this is an issue that so many school leaders are facing, so we figured it would be a really good case to cover here on the show, especially because the student here makes pretty much every single argument you could think of to try to get his punishment thrown out. Yeah. So it's another spaghetti case. Yeah.
Exactly. Yep.
Is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Jamie, before we dig into our AI case, do you have a bell ringer for us?
I do. So this bell ringer is from about a month ago or so. And like today's case, this bell ringer also came out of Massachusetts. So
nice. We got a twofer today.
A twofer in Massachusetts. So in this particular case, we've got a district policy that allows students to determine whether or not their parents should be notified about gender transitions, name and pronoun usage, and all of those things. So we've talked a lot about these kinds of issues on the show before, and courts have ruled kind of all over the place on these things. But recently, this is out of the First Circuit, so a unanimous 3-judge panel said that policy, quote, plausibly creates a space for students to express their identity without worrying about parental backlash, unquote. Yeah, so basically, they said that policy was perfectly fine. Now,
okay, a policy that made it the student's decision whether or not the school would tell parents about the child's transition.
Yes. Now,
okay.
We've talked about this before. We know that there are a number of states that have introduced these Parental Rights Act that basically
would require schools.
Require schools to inform parents and things like that. So, I know that it's hard. Sometimes you tune into the show and you're like, they're going to tell us what to do and what not to do.
If only the law were that simple.
Yeah, it is not. And
not when you're talking about parental rights and LGBTQ issues right now.
Exactly. Like this stuff, honestly, it's all over the place. But yeah, I think eventually we're going to get to this sort of critical mass of legal challenges and issues and cases and whatever. Right. And we will ultimately have some goalposts here.
Right. And I mean, I think we're going to get some of those this term because the Supreme Court is hearing a case about parental rights in relation to like gender affirming care.
Yep.
So it's not specifically a school case, but that's a case that's going to have some implications for schools. We talked about it already, but the Supreme Court's also hearing Mahmoud versus Taylor, which we did an episode on, and a bell ringer just recently.
And that's a parental rights.
And that's a parental rights case too. So so we're going to get some guideposts. And, you know, the more cases we have that start to create maybe like a general consensus about where the different lines are and how to balance all these different interests, you know, all of that is part of the process. So it's interesting to hear this First Circuit decision that seems to affirm students' rights in the face of kind of, let's say, competing parental claims.
Right.
Yeah. Interesting.
Yeah. So I found that interesting. So I figured I'd share that today.
Yeah. What's the name of the case?
What's the name of the case? The name of the case, I believe, is Foote versus Ludlow.
Oh, okay.
So we'll keep our eyes on these kinds of issues. We'll keep telling you about them, folks. So you want to talk about the other Massachusetts case, the big one for today?
I do, yeah. I don't think we've ever had a Massachusetts twofer.
Well,
we've had Florida, we've had Oklahoma.
This is a first time for everything, man.
First time for everything.
That's right. All right.
Got to share some of the love.
So this is a fun one. So I don't know if anybody here who's listening to this podcast has heard of AI, but it's a thing right now. It's all the rage.
2 years late.
I know, it's all the rage. They're talking about it on the YouTube. Sorry. So yeah, but like AI, obviously, you know, we don't need to go into it. We did a bell ringer on it a number of episodes ago when we talked about.
Right. Yeah.
You remember that? We talked about the image generation where, you know, these kids were using AI to generate fake nudes of classmates and things like that and everything. AI is like, it's a huge topic in schools right now. It's like, how can it be used as a helpful tool and how can we prevent its misuse? Right.
Right. Yeah. And that misuse around things like academic integrity and cheating, plagiarism, all of that stuff, like those have been huge concerns for school leaders and teachers.
Yes.
Since, you know, ChatGPT came on the scene in late 2023.
I mean, I would argue this stuff has been of concern to students and teachers since like the calculator came out, right? Like
it's similar arguments, right?
It's a similar kind of situation that, you know, involves largely a technological tool that becomes available. And, you know, schools are historically pretty slow to kind of respond to these kinds of.
Well, let's just say the students respond faster.
Yes, absolutely. I remember dealing with this when the iPhone came out and, you know, and we dealt with this when texting came, you know, cell phones and pagers in school. And, you know, even though pagers didn't really serve any sort of academic purpose, but, you know, like schools are constantly trying to respond to these advancements in technology and figure out whether or not their presence in school or how to handle their presence.
How to handle them, right.
Right?
Yeah.
And so AI is just like, it's in the last couple of years just taken off.
Yeah. And we're finally starting to see some court cases on it.
Yeah. And I mean, listen, if anybody has played around with this, and I feel I'm assuming a ton of our listeners have played around with this, like it's unbelievably impressive stuff, but it's also just a piece of technology
with its challenges and let's call it ethical issues.
Exactly. So we're going to explore some of those challenges and ethical issues today. So anyway, so today we've got a case of a student named RNH, is a junior at the time that this whole thing started. And he was disciplined for using AI to cheat on portions of this history project that he was assigned in his AP history class. So the decision we're talking about today is the court's adjudication of the student's motion for a preliminary injunction. Okay. I said, I didn't
Better
even mess that up.
No, you nailed it.
I don't know what any of it means. No, I'm just kidding. I do, because I listen to Chalk.
I was going to say, we've talked about it enough on this show.
So basically, and this was similar to the last case we talked about a couple of weeks ago, right? It was also about a preliminary injunction. So in this case, we had a short evidentiary hearing. And so we were able to get most of the facts out, even though there are some spots where things are still a little hazy. We were still able to hear, you know, from both sides and gather a little bit
Right.
more information.
Yeah, we've got a bit more fuller of a picture.
Yeah, exactly. And so just quick reminder, preliminary injunction, that's the plaintiffs, in this case, the parents, asking the school to stop doing something that they did, which was punish this kid.
Mhm.
Okay.
Yeah, basically they're seeking a court order to undo the punishment at
Right.
this point.
Yes. Okay.
Because they argue that if they don't, the student will suffer irreparable harm because he is currently, as the time of this lawsuit, in the process of applying for college.
Yeah. And listen, I get how stressful the college application process can be for many people, in terms of timelines and, everything. It can be a pretty stressful process, but I don't know. When you say irreparable harm, and I think back to the point that you made at the beginning of the episode about how this was all about going from a C+ to a B.
In one class.
In one class, I'm trying to reconcile how one class out of this kid's entire career is going to, a 3 percentage point, whatever, roughly 3 percentage points, is going to cause irreparable harm. I'm having a little trouble reconciling that, but
yeah, well, we'll talk about it.
Let's talk about it.
Yeah.
All right. So we've got this student, RNH. This is September 2023 when all of this started. He's a junior, and he is described as a 3-sport varsity student athlete with a high GPA. Okay. How high, you ask?
How high?
Thank you. He's got over a 4.0.
Okay.
And
while doing 3 sports. Busy
doing 3 sports. They say he's in the top of his class. He scored a 1520 on the SAT. And this is a fun fact. He scored a perfect score on the ACT.
Hey.
Yeah. Which apparently that puts him in the top quarter of 1% of students who take the ACT. So,
hey, that's not bad. That sounds like a pretty good kid.
This guy, yeah, it sounds like he can do school.
Yeah. Or at least do tests.
Yeah. Or at least do tests. Right. So everything takes place in the fall of 2023, but the court decision here is about a year later. Okay. And so he's a senior when the decision is sort of coming down in the courts. So he's applying for colleges at this point. So that probably helps to explain a little bit of the relief that the parents are seeking in this case.
Right.
So according to the complaint, RNH plans to apply for early decision to elite colleges and universities such as Stanford University.
Ooh.
All right.
Okay.
So he's aiming high.
But he's going West Coast, which Massachusetts isn't on the West Coast.
Yeah. No, it is not.
No. I mean, I'm surprised he's not going, Ivy.
Ivy on the other side. Yeah.
Maybe his lawyers went to Stanford. Maybe that's why they did that. But so I guess you could see why every little thing matters. And so, we haven't mentioned it yet, but he got disciplined for this academic misconduct thing, got a Saturday school, got a C in the class, C+ in the class. There might be some blemishes from this incident that the parents want off of his record because they're worried that colleges are going to see that and it's going to raise some red flags.
Well, maybe not. And maybe not just raise red flags, but we all know how competitive.
Right. Especially if you're going for these kind of schools. Right?
Exactly.
Yeah.
Going for these schools, it's massively competitive. You are, throwing your hat into the ring with hundreds, if not thousands of other very similarly qualified candidates.
They
right?
probably don't all play 3 sports though. I'm just guessing.
You never know.
That's true. Yeah. High school is so different than when you and I did it.
It's so exactly. So the parents obviously they don't want to take their chances. Right.
Yeah.
So in September of 2023, Miss Petrie, which you would think would be the science teacher.
The science teacher, right?
It's not. Yeah. It's the AP US history teacher. And she assigned a project for National History Day. So the assignment asked for students to conduct primary and secondary research on a topic of their choice and present their findings in the form of a paper, a website, a documentary, or a performance. Okay, so they've got lots of different ways that they can demonstrate their knowledge and understanding of the topic.
Yeah, and they get to choose their topic, which is even Like, that's exciting.
Yeah. They also get to choose whether or not they want to work with a partner.
Nice.
Lots of choice here.
It's a good assignment.
Yes. But this brings us to our first wrinkle. So there was apparently a little bit of disagreement about the instructions that the teacher gave when she was talking about the assignment with respect to the use of AI in that project. Okay.
Right.
So according to the teacher, she told them that they could use AI to brainstorm the topic, but they could not use AI for the content of their notes, their script, their final project. Basically, she was saying, listen, you want to use it to kind of just poke around and brainstorm and get some ideas, that's fine, but do not use it to generate any part of your final project.
Okay. Yeah.
Okay.
That's kind of actually how I treat it in my syllabi. I basically say that AI can't be the first author.
Oh, that's an
right. So basically, you just can't copy and paste it and put it off as your own.
Yeah. Yeah. So, this is where the some of the disagreement lies, because RNH initially claimed that he didn't remember his teacher giving those instructions at all. But then later he testified that his teacher told students they could use AI for parts of the assignment, but he couldn't really remember what parts she was talking about when she said it. But he did say he knew that she said using AI for brainstorming was okay.
Okay.
He just didn't know if they could use it for other parts. He couldn't remember.
Other stuff. Yeah. And what RNH knew or should have known and his intent is a big part of this story.
Right. Right. So RNH, he got a partner and they chose to do their project on Kareem Abdul-Jabbar, famous basketball player. They decided to create a documentary, and that would be their final submission for the project. Okay. The students had to submit their script to an anti-plagiarism software thing, and it's a very common one. It's called turnitin.com. Lots of teachers use it. Lots of professors use it. And so that website flagged parts of the submission as AI generated.
Dun, dun, dun.
Yeah. And we've kind of talked a little bit about this on the show. I think we've talked about it on the show. Maybe we've talked about it with, like, you and I have talked about it, or we've talked about it.
No, we talked about it on the show in one of the bell ringers about like how the AI detection tools aren't 100% accurate, and they'll flag, they have some problematic biases.
Yeah, exactly.
Yeah. Yep. No, that was a bell ringer.
Okay, good. So the script was flagged. The history teacher looked at the revision history of the document and noticed that large portions of the script were copied and pasted directly into the document. Now,
right. And that's huge because this is all on Google Docs.
Yeah.
And Google Docs lets you see revision history.
Yeah.
Right.
Exactly.
Yeah.
But at the same time, like, there have been a number of times when I have written things in Microsoft Word, for example, and just copied and pasted them into a Google Doc for some other, for collaborative purposes or things like that. So it's an interesting piece of information, but it's not a smoking gun, so to speak.
Except at the school, they were instructed to do all of their drafting in the Google Doc. So part of the instructions were, don't type it somewhere else and then copy and paste it. So it is a smoking gun.
So there's your problem. So yeah. So in this case, that is a little bit more of a smoking gun. Okay. Because they were specifically given instructions not to do the thing that I just said.
Right. But even more important.
Oh, even more important. Yeah. Was that the revision history showed that RNH only spent about 52 minutes working in the document, where the teacher explained that other students spent between 7 and 9 hours in their document. But here's another interesting thing, though, is like there are a lot of tools at everybody's disposal here. Like, there's a lot of tools at students' disposal, but there's also a lot of tools at teachers' disposal as well. When you look at these AI detection software things, when you look at the fact that you can look at the revision history and how long somebody's been accessing a document and things like that, and you can track all their changes. On one hand, you could look at it as sort of very big brother-ish, but on the other hand, these are just tools to help paint a more complete picture about what's going on.
Right. And to ensure academic integrity, right? Like, that's the
100%.
Kind of the goal with
100%.
a lot of those practices.
Right. There are far more I guess another way to put it is there are far more tools at students' disposal now that could compromise academic integrity.
Or the learning process, yeah.
Yeah, and the learning process than ever before. Okay? And so, we've got these other tools on the other side that help to identify when those things are happening. Anyway, the teacher decided this was suspicious. So
understandable.
So she ran the draft through 2 other AI detection tools, both of which indicated that AI had been used to generate portions of that document. Okay? And here's another dead giveaway. 2 of the sources that RNH cited in the draft don't even exist.
Oh.
Okay? And he cited at least 3 non-existent books. Okay?
So basically he's citing AI hallucinations.
Yeah, this is something that happens in AI, all right?
Yeah.
AI will say, here are the facts and here's where they come from.
But it ends up just being an amalgamation of a bunch of different sources and things like that.
Yes.
Because I know there's some really now famous stories about attorneys who have turned in documents to the court with AI hallucinations in them that are like made up cases that don't actually exist. There was a really early one from New York a couple of years ago where the judge actually made the litigants, the lawyers that turned in these fake cases, they made them contact the judges of the like supposed cases and say, hey, I don't know if you're aware, but AI made up this case that you didn't actually decide. And I just thought that was a really funny punishment. But like, I'm not surprised that it's catching some high schoolers off guard because, there are professional attorneys who have messed this up too. So,
yeah. So, I mean, I think like there are, up until this point, lots of red flags and a few, we're probably pretty clear that we got some smoking guns here. And then when you throw in the completely fake references that AI is known for,
right?
Like, it's pretty, at this point, it's pretty black and white. Okay.
Right. So you've at least got enough to talk to the kid.
Yeah. Which is what Mrs. Petrie did, or Petrie. So the history teacher meets with RNH, shows him the Turnitin results and the revision history, kind of lays out the case here. And at that meeting, she explained that she would turn the draft script over to the director of the social studies department, and that person would review it. Okay?
Yeah. So just pass it up the ladder.
I'm just letting you know, here's what I found. I need to pass this on to my boss, basically. Yeah. The next day, after reviewing the document, the department head came to the same conclusion that it had been AI generated, or portions of it had been AI generated. He, the department head, then met with RNH to discuss the assignment. And according to him, at that meeting, according to the department head, at that meeting, RNH admitted that he had used Grammarly to, quote, generate ideas and, quote, create portions of the draft script, copying and pasting language directly from Grammarly into the document.
Okay, so slam dunk.
So he just admitted to using, Grammarly, for those of you who don't know, basically is like spell check and grammar check in Word on major steroids.
But it also has AI chatbot generation.
Yeah, you can say, I want to rephrase this paragraph so that it sounds more like this or does that or whatever, and it'll do that.
It'll also generate content for you.
Yeah. So
obviously, because that's what
happened.
RNH did.
So later that day, the history teacher, the social studies department head, both met with RNH to discuss the situation. And at that meeting, RNH was very forthcoming, apparently, even describing the prompts that he used to generate the content.
Okay. So it's not just like, I did it, but, I did it. And here's how I did it.
Here's how I did it. Yeah, exactly.
Okay, good. I mean, hey, I appreciate the kid being forthcoming.
Yeah. But, here we go. So according to department head, it was clear that RNH knew that his actions were not permitted for the assignment. So I think this is probably a good place to talk a little bit about the school's academic integrity policies, because they're going to come into play here.
I was going to say, it sounds like somebody's about to get in trouble.
Yeah. So let's see what the handbook says. The handbook.
Always go back to the handbook.
Let's go back to the handbook. The handbook says To cheat is to act dishonestly or unfairly in order to gain an advantage. In an academic setting, cheating consists of such acts as communicating with other students by talking or writing during a test or quiz, unauthorized use of technology during an assessment.
I appreciate
I added the emphasis
there.
myself.
Yeah, because I think that's going to be really important.
I think that's the phrase. Or any other such action that invalidates the result of the assessment. Plagiarism consists of the unauthorized use or close imitation of the language and thoughts of another author and the representation of them as one's own work. Plagiarism and cheating in any form are considered disciplinary matters to be addressed by the school. A teacher apprehending one or more students cheating on any graded assignment, quiz, or test will record a failing grade for that assignment for each student involved.
Oh, so that's mandatory. Will record. There's
That's
no discretion there.
The teacher, that basically is being very clear about what the consequence is if you violate that policy.
Right.
It also says the teacher will inform the parents of the incident and the assistant principal, who will add the information to the student's disciplinary file. The assistant principal may take further action if they deem it warranted.
Okay,
That's what
it's going on your permanent record.
Right. That's what's in the handbook.
Okay.
Now, notice
That
it doesn't
didn't
say
say-
anything about AI,
Right. Yeah.
right?
It says unauthorized use of technology.
Yes. Which, I mean, technically is
AI is a technology, but it doesn't say do not
unauthorized.
use AI.
Right. It doesn't, but she kind of said it in her instructions. Now, again, that's disputed, but
Right.
not
The history teacher.
so much.
Yeah.
The history teacher. Yeah.
Yep.
But it's not disputed so much. Like he did end up coming back saying, yeah, I know she said something about it. I can't remember exactly what.
Right. Well, and it's not just the history teacher said something, but the school was also doing some stuff at this point as well around AI use and academic dishonesty.
Yeah.
It wasn't in the handbook, but there was some instruction in like the English language arts classes about the use of AI and how that related to academic integrity.
According to the teacher, that included setting expectations for the use of AI, sharing a one-page document of expectations for AI use and academic dishonesty. That one-pager instructed students to, quote, not use AI for assignments unless explicitly permitted and instructed, as AI tools should not be used to replace the student's own critical thinking.
Okay. Pretty
All right.
black and white.
Pretty black and white. If students do use AI tools, the document also required that students communicate that use with their instructor in advance and appropriately credit AI tools whenever used, which I guess one could say he inadvertently did by throwing in those completely fake references.
Well, I don't know if that's what it means.
No, I don't think that was his intention to give credit to AI, but that's what he did.
Well, he
Sorry.
also did it when he got called out on it.
Yes, exactly. So, what did this all mean for RNH's National History Day assignment on Kareem Abdul-Jabbar?
Seems pretty cut and dry, like unauthorized use of technology, passing off the words of someone else as your own. Like, there's this AI policy document that we got in our English language arts class. Like, I'm struggling to see where the issue here is.
Yeah, and the social studies department head also struggled to see where the issue was, because he said, listen, this is clearly a violation of our academic integrity policies. And so that ended up, as per their handbook, resulting in some disciplinary consequences.
Okay.
All right. So here's what happened. On the academic side, RNH received a 0 on 2 of the 6 components of the assignment. So didn't fail the entire thing, only got a 0 on a third of it.
Yeah, probably the parts that he copy and pasted from Grammarly.
Exactly. He was permitted to start the assignment over on a new topic alone, not working with a partner.
Oh, interesting. Okay, so
he
got
was
a 0.
given the choice to basically have a do-over.
Okay.
Okay. It didn't seem like, from what we kind of poured through, it didn't seem like RNH chose to take them up on that offer, because he received a final score of 65 on the whole project. Okay.
Ouch.
On the written portion of the project. And that left him with a 63 for his second quarter grade. Okay.
What else happened second quarter, bud?
Well,
because a 65 is actually higher than a 63, which means that there was other stuff that he did worse on.
Yeah, exactly. So for the full year, RNH received a grade of 78.75, which translated to a C+. So we are talking about 1.25 points away from a B, assuming that an 80 is a B in this district.
Right, or a B minus. So who knows how far it gets us to get to a B.
Right. So that's what happened sort of grade-wise with him.
Okay.
On top of that, RNH was required to attend Saturday detention in January of 2024. So he got a Saturday school for that. So
do you think he reenacted Breakfast Club?
I was just going to say Breakfast. All right. And I'm sure listeners, that's what you all were thinking too.
I hope so.
Yeah.
Our listeners at least.
Yeah. And the last thing was that he was rejected for admission to the National Honor Society in March of 2024, though he was allowed to reapply the next fall and was ultimately admitted. So basically, he had the grade consequence that resulted in a C+. He had a Saturday school detention, and he had to sort of wait to reapply for National Honor Society.
Okay. Yeah.
Right.
So, I mean, like, honestly, not that significant, it seems, especially given the fact that he had the opportunity to redo the assignment, but it sounds like maybe he didn't.
That's the thing that really kind of floors me here.
Yeah.
Is that they had the ability to do something that could, now maybe it wouldn't have expunged the Saturday school detention or the National Honor Society thing, but it could have resolved the grade issue.
Yeah. Yeah.
Anyway, here's where things get kind of weird. So,
okay. Oh, good. Okay. Well, I'm glad.
Yeah. But wait, there's more. So part of RNH's complaint against the school alleges that his teachers and the school principal and the NHS, the National Honor Society advisor, engaged in, quote, a pervasive pattern of threats, intimidation, coercion, bullying, harassment, and intimidation of reprisals against RNH.
Sorry?
Yeah, I think that's what the court said too.
Yeah, no, I think, yeah, we'll get to that in a second. But this is one of those fun cases where I think the school did everything right. And spoiler alert, the court kind of agrees.
Yeah. The court was really skeptical of that claim because they said, in their submissions to the court, however, plaintiffs provide little in the way of factual allegations along those lines.
That's such a polite way of saying,
you're full
I don't see it.
Sorry. Oh.
Yeah. Yours works too.
So here are the actual allegations that were made in that regard. School staff leaked information about RNH's academic misconduct disciplinary matter too widely in violation of FERPA.
Okay, so maybe they told some people they shouldn't have told.
Well, maybe they told people that the parents think shouldn't have been told.
Right, yeah, because if there's a legitimate educational reason, like FERPA, that's
exactly.
FERPA allows that.
Exactly. There was also an allegation that the NHS advisor said that RNH's cheating was, quote, the worst episode of academic dishonesty we've seen in 16 years, unquote, and that she discouraged him from reapplying to the Honor Society.
Oh, okay. So that kind of answers one of the questions I had, which is like, how did RNH connect the dots between his cheating in history to not getting into the National Honor Society? It seems like the advisor strongly disagreed with maybe some of the character and fitness aspects, I suppose, of his application.
Oh, yeah. I mean, exactly. Okay. Yeah. So, and then lastly, there was an allegation that the history teacher tracked RNH to another class and accused him of doing work for her class in this other class, even reporting the suspicion to the other teacher.
Oh, okay. So there's like this, my history teacher is out to get me.
Yeah.
She doesn't like me. Okay.
Yeah.
No.
So
I guess.
Yeah. The court doesn't seem too concerned about these things, but it does say that the school officials created a safety plan for RNH, which, quote, set parameters around certain defendants' interactions with RNH.
This goes to something that you talk about a lot, which is like, even if there's no smoke or even there's no fire under this smoke, like the school is taking it seriously and is like putting in affirmative steps to kind of try to,
like
at the very least protect the school, but also like defuse the situation.
Right. And listen, from the school's perspective, you potentially have what seems to be a pretty clear-cut violation of policies. Okay. And you have kind of done everything that you were supposed to do. You have potentially gone out of your way to do more by allowing the student the opportunity to completely redo the assignment.
Right. Yeah, because the policy just says you will fail the assignment.
Exactly. And after all that, what it sounds like is it sounds like you've got the parents who are potentially creating a lot of noise, so to speak, and maybe anger or whatever. And if that's the case, I can completely understand why people in the school would feel sort of like, hey, we're doing our jobs. We're only doing what we said we were going to do. You know, the student admitted to all this. We have all this evidence. We've kind of bent over backwards to give him an opportunity to redo this so he doesn't have the grade, and they're still coming after us.
Right.
And so the school is basically saying here, like, all right, everybody, don't forget you're professionals, just let's let this thing play out. Don't do anything that's going to make us look bad. Or
don't overreact. But like, I like what you said, like, you're professionals. We'll just keep acting like professionals. Right.
Yeah.
Because there was also, like, at this point, the school investigated some of these allegations that RNH was making about, like, being bullying or harassed by staff.
Yeah.
And that investigation didn't turn up any evidence of wrongdoing. So, like, the school is doing its due diligence.
Yeah. So, here we are. What happens next?
Right. Well, they did what everyone does in an episode of Chalk and Gavel, and they filed a lawsuit, I guess.
Oh.
This is one of those where, like, so actually this came to my attention because a student actually presented on it in my school law class.
Oh.
And another student's response was, they sued over that, which, is a response that sometimes happens in school law cases, but they sued over that, which is good because now we have a court decision to talk about.
There we go.
So thank you, I guess. And I'm sorry for the school who had to go through this.
Doing it for Chalk and Gavel.
Yeah, much appreciated. So on September 16th of 2024, so RNH is now a senior, getting ready to apply for college. Him and his parents file a lawsuit against the school and its employees, alleging violations of the United States Constitution and the Massachusetts Declaration of Rights.
Oh, boy.
Yeah. So they are essentially arguing, actually, they're asking the court to undo the consequences of the punishment that RNH received for the improper use of AI.
Okay.
And they're arguing a couple of things. Well, a lot of things, but broad strokes. They're arguing that,
like, due process, right?
Yeah, they're arguing due process, like that the academic honesty policy didn't cover AI use, that it was unfair to conclude that RNH violated the existing policy, and that the penalties imposed were just too harsh for what it is that RNH was accused of doing. So a lot of due process arguments.
Oh, so they would disagree with our characterization that this was kind of light discipline.
I believe they would have, because, you don't bring a lawsuit over.
Yeah, but they did.
But they did. So we end up in federal court because these are federal claims. And RNH, as we talked about, moved for that preliminary injunction. They were asking the court to expunge the disciplinary record, so take the Saturday school off his record, and then to raise his AP US history grade from a C+ to a B.
Okay. So in a sense, they're not really asking for a lot because,
it's not a lot. No, like, they're only asking for declaratory and injunctive relief, which I think, like, to the school's credit, they don't just kind of like say, that's it. Like, yeah, I guess.
No, exactly. Exactly.
Right. So, but we're still really early in the process. So who knows what's going to happen? But spoiler, the parents do not win their motion for preliminary injunction. So, like, the record, the Saturday school is still on the record and the student still has a C+.
Right.
So we've talked about the elements for a preliminary injunction, the most important of which is you have to prove a likelihood of success on the merits.
Okay.
And so we have to look to see, is there anything here that RNH can point to say that his rights were violated?
Right.
And Jamie, like you said, these are all due process complaints, at least under the federal constitution, which is the only one the court addresses because don't need to worry about the Massachusetts stuff if they're not going to win the federal claims.
And I would just say, like, as a reminder on due process is we are talking about when you take away somebody's rights, okay, you have to go through some stuff to ensure that
process.
Yeah, you've got to. I was trying not to use the word in the definition. I was taught that a long time ago.
No. But yeah, you're right. Like there are two flavors of due process, right? Where there's procedural due process and there's substantive due process.
Right.
And procedural due process is the steps that the government has to go through before they can deprive an individual of life, liberty, or property.
Right.
And in the educational context, we've got property interests in our education because statutes basically say kids can go to school. And so they're entitled to go to school. And we've also, especially in this case, we have liberty interests in our good name and reputation.
Oh.
And that's a really interesting one. It basically says like you can't, like the government can't go out of its way to badmouth you.
Right.
In ways that harms your reputation. Right.
Right.
And that's what R&H is arguing for. His procedural due process complaint is that he didn't get the procedures that he deserved before he got in trouble and before the school started to disparage his character by concluding that he engaged in academic misconduct, right? Academic dishonesty.
But we also know from many, many cases, I can't even think, Wood versus Strickland, maybe, I don't know. There's
Goss versus Lopez?
Goss versus Lopez, right? That basically said, and a lot of these things deal with suspension, right?
Right.
And because you are removing kids from that academic environment,
right?
You're depriving them of opportunities to learn, that sort of property interest that you talked about. And Goss versus Lopez and some of these other cases have basically said, everybody gets due process, but how much due process is determined by
the deprivation,
how much you were deprived of that.
Exactly.
Liberty interest, right? So, we have this threshold in schools of 10 days. 10 days is the maximum. And then if you are going to be suspended for more than 10 days,
you get more process.
You have more process. Yeah. And in this case, there's not even a suspension.
Exactly. And that's what the court says. The court says nobody here was denied a property interest in education because asking someone to go to, or telling someone they have to go to Saturday school doesn't take away their opportunity to go to education. So the court says, like, even if that triggered Goss v. Lopez, which it doesn't, the school is fine here.
Yeah, because they don't. You need minimal process.
Right. And minimal process, exactly. Yeah. And for the liberty interest in the good name and reputation, the court says, like, I don't even know if that's implicated here, but even if it is, then all that's required is what Goss versus Lopez requires, which is notice in a hearing.
Yeah.
And notice in a hearing is minimal process that just requires the school to tell you what you're accused of, to give you the evidence that it has that shows that you violated the rule or the law or whatever it might be, and then an opportunity for you, the student, to tell your side of the story.
Yeah, it doesn't say anything about whether or not you have to believe the student's side of the story.
Right. It just says the student has to have a chance to tell their side of the story. And so that, like minimal process is all that's required. And the school here gave way more than that. So the court looks at this procedural due process argument and says, you got plenty of process. You got tons of meetings. You got tons of chances to tell your side of the story.
Right.
Like there's no question here that you got enough process, which leads us to the other side of due process.
A substantive. Yeah.
So to make out a substantive due process claim in this context, substantive due process basically protects individuals against arbitrary governmental action. We don't want the government to be doing unreasonable things to individuals, right?
Yeah.
And so in the educational context, in order to prove that something is arbitrary in the constitutional sense,
it's got to shock the conscience.
It's got to shock the conscience. Exactly. Yeah. And that means that it has to be like truly outrageous, uncivilized, or intolerable.
Yeah, like you got to look at something and go, holy crap, they did that?
They did what? Yeah, they taped a kid's head to a tree.
Yeah,
exactly.
Right.
If we talked about that case. So like for school discipline to shock the conscience, there has to be no rational relationship between the punishment and the offense. And here, like,
it's pretty obvious.
This is pretty obvious, right?
Yeah.
It is very clear that everything the school did was reasonable.
Yeah, they had it in the handbook. There was a lot of conversation around AI. Even if it wasn't explicitly mentioned in the handbook, there was a lot of conversation around AI. The consequences were reasonable. They were aligned with school policies, right? Like, there's nothing conscious shocking here.
No. And like, to get around that, R&H kind of argues that he thought the AI policy was just specific to the ELA classroom, which is where they talked about it. And the court just kind of says like, well, one, no, you didn't, because there's other evidence that says you knew exactly what you were doing. And two, like, you know, it's reasonable for the school to conclude that if you thought what you were doing is okay, you would have done what we told you to do, which was to cite your use of AI or ask permission to do it before you did it.
Yeah.
And you didn't do that. So, you know, we can kind of infer from that you knew what you were doing wasn't appropriate.
Right.
And then my favorite line from this whole part of the judicial opinion, the court says, quote, in light of the evidence developed to date, R&H's testimony that he was confused smacks of after the fact rationalization. Because the court is basically saying like, look, dude, you got in trouble. Stop trying to weasel your way out of it.
Just own it and move on.
Exactly.
Yeah.
But the most important part here is the court flat out says courts are not in the business of second guessing school disciplinary decisions.
Which is something that the courts have said over and over
Right.
again. Right.
Yeah. And so like here, the court says all of this was reasonable. It's totally in line with what you were accused of doing. Like, we're not going to micromanage these school decisions.
Yeah.
Even if we agreed with you, which we clearly don't.
Like we said, it's about the conscious shocking thing. Like the court's job in most of these kinds of situations is to just determine whether or not this was like way over the top.
Right.
And if it's not, then we're staying out of it.
Exactly. Right. Yeah. If it's not, then that's something for the school to deal with.
Yeah.
And just because you didn't like how the school handled it, that doesn't make it unlawful.
Exactly.
But I get to do it now. But wait, there's more. I don't usually get to do that for the law side of things.
I know. Yeah.
R&H and his parents make a bunch of novel arguments about AI and the school's academic honesty policy. And these arguments are exactly as persuasive as their previous arguments. That is to say, they aren't very persuasive, but I think they're worth talking about because I think they will really help schools as they think about how to apply existing policies to AI.
Great.
So the first thing that the student here argues is that the school's academic honesty policy did not expressly prohibit or regulate the use of AI, and therefore the policy was vague and didn't provide sufficient notice to R&H that his conduct was forbidden.
Okay.
So yeah, like, right, the policy doesn't say anything about AI.
Okay.
If it doesn't say anything about AI, how's R&H supposed to know that what he's doing isn't okay?
Right.
Well,
you can't spell out every single possibility. At some point, you have to rely on people's ability to understand and interpret the information that they give you.
Right.
In a
And that's exactly what the court says. The court says, like, number one, the policy clearly covers cheating, dishonesty, and passing off someone's work as your own.
Right.
And it also mentions the unauthorized use of technology. So sure, it doesn't say AI in as many words, but it covers this.
Yes.
Right.
Yes.
And the court says like the policy is good enough as is.
Yes.
And then Jamie, that's the real kicker. What you just said is the courts have said that school rules don't have these same expectations for vagueness that we would expect from things like the criminal code. Instead, schools can punish students for offenses, quote, without a prior rule specifically forbidding the conduct, end quote, as long as the school's actions are reasonable. You don't have to have a list of every single thing that is against the rules in order to enforce behavior in schools. Because, Jamie, you said it exactly right. Like, schools are dealing with child development, and that's a lot. There's a lot of nuance there, right? So, like, we don't have to have explicit rules to cover everything.
You don't have to have a rule. Like, there doesn't need to be a rule like that says don't pee in the corner of the classroom. Right? Like,
yeah,
you're probably going to get in trouble if you do it.
Yeah, probably. You taught middle school, so I hope that didn't come up.
No, that never came up. I'm very glad that never came up.
Oh, good.
Yeah.
Whew, you had me worried there for a second. So the next thing that R&H argues is that the school's procedures for investigating and doling out the punishment were unconscionable. So he objects to how the investigation itself was done, because apparently the school talked to the two students separately. They met with them on multiple occasions. They didn't involve the parents during the investigation. They told them about it afterwards. And they talked to R&H without his parents present.
Yeah, that happens all the time.
And that's exactly what the court says. The court says none of this violates any rights that you have. Like,
yeah.
And plus, there's no evidence here that like you were coerced or like there's anything improper with how the school
It all
acted.
sounds standard conversations.
Exactly.
Trying to gather evidence and information about what happened.
Exactly. And so the court says, nope, that's all totally fine. Like, there's nothing wrong with that. Next, R&H argues that his conduct couldn't be considered cheating because he had no guilty mind. He had no intent to engage in academic misconduct. Mens rea. Yeah, and that's exactly what the court says. The court
did?
Says,
Did they go,
Because under the policy, the policy prohibits academic misconduct, whether done knowingly or unknowingly. So there's actually no intent requirement at all. So boop, that one's out of here as well. And this is the last one I'll talk about. And this one's my absolute favorite because R&H argues that it can't be plagiarism because he copied AI-generated text and AI can't be an author. So therefore, he did not copy the text of another person.
Wow.
It's brilliant, right?
Well, I don't know if I would say it's brilliant.
It is a good argument. It's not a winning argument.
I would say that he's thinking outside the bot.
Oh my God.
Get it, folks? He's not thinking outside the box. He's thinking outside the bot, the AI bot. Oh boy. I'm done.
Oh boy.
It's Friday. I need to be.
I was going to say, I'm getting over a cold, which, you can probably hear. And I think that one sent me back a week.
That was terrible. That was one of the worst ones I've ever made.
Well, I don't know if I did that.
But yeah, you're right. It is definitely a stretch of an argument.
It's a clever argument. And there's some accuracy here.
Yes.
Because you can't copyright AI generated work because it lacks human authorship. So there is something to be said that AI generated content is authorless.
Yeah.
For the court, this doesn't pass the smell test.
Yeah.
For a lot of reasons.
Yeah.
And the court says, quote, even if I were to credit R&H's testimony that he was confused about what uses of AI were permitted, it strains credulity to suppose that R&H actually believed that copying and pasting without attribution text that had been generated by Grammarly was consistent with any standard of academic honesty.
Yeah, and that makes perfect sense to me. It's like...
Right, yeah. R&H didn't write it. How are you going to pretend it's yours?
Yeah, don't pretend... It's not about who did or who didn't write it. It's about the fact that you didn't.
Exactly.
Right?
And that's what the court ultimately comes down on. And so, the court disposes of all these, let's call them creative arguments, and just says, look, there's no due process violation here.
Right. Yeah.
Without a due process violation, you are unlikely to succeed on any of your claims. Therefore, I don't even need to worry about the other elements, but even those don't help you.
Yeah. So we're done. We're tossing.
So we are done. So the court denies the motion for a preliminary injunction.
Great. So, it's a great case because it's timely. These are things that schools are dealing with every day.
And it's a situation in which the school seems to have done everything right.
Exactly.
Right? They had a policy. They explained the policy. They talked about explicit expectations for this use of new technology. They put in place proactive measures to catch academic integrity issues with the turnitin.com stuff, as well as track changes and all that stuff in the Google Docs.
Right.
They investigated thoroughly. They followed their procedures. Yep. They gave the student a second chance. I think the school handled everything incredibly well.
It sounds like they did. It sounds like they did. But, we also shouldn't look at these situations, where we really can't find any fault with how a school handled it, and not there's one of the reasons why we're doing this and talking about it is to give, not just give people a roadmap, but just make them think about these things because you know what? There are some takeaways. There are some things that schools might want to do differently in light of, something like this, which is you know what? Maybe we do need to have a specific AI kind of language in the, in
the handbook, right?
And maybe it's as simple as saying unauthorized use of technology, including AI. Maybe it's as simple as that, right?
And maybe the school does now because they learned their lesson.
Well, yeah. And this is
Right.
normally how policies evolve is somebody gets sued and we rewrite the policy.
Yep.
But, don't forget about your obligation to, when these really nuanced, complex kinds of situations that are oftentimes hard to evaluate, hard to, respond to or whatever, like we have to be extra careful about consistent application of policies and procedures, right? And
how they're communicated.
So these are all really important things for schools to continue to think about as they navigate AI's presence, in their building.
Sure. Yeah. And I think like another thing to talk about here is like, there's obviously some breakdown in relationships as well. So, while I think the school did the right thing and like went through the process, like something happened here that led to the parents feeling like their only recourse was a lawsuit. Right. And I don't know if that means that the school didn't do enough to like work with the parents, but like, there's something here about like open communication and things like that. And again, like that isn't necessarily part of the whole story, but like it's us reading between the lines about, why did this end up as a lawsuit? And
right.
That's a question that like,
we don't know. Like we have no idea, but you're right. Like whenever we talk about these things, we always have to consider that, right? Always got to consider, what are the relationships like? Who are the players here? How do we get to this? Maybe some of the interactions between the school and the parent were not so pleasant, and maybe that was partly the school's doing. Who knows?
Right. Yeah. We don't know what those meetings were like.
Right.
We know that there were some meetings that took place because the court records mention some meetings between like the acting superintendent and the parents and their attorney and the student.
But what we have to remember is these court cases, these lawsuits are concerning the law. They are not about, I'm filing a lawsuit largely because this school administrator really made me mad because of how they spoke to me. That's not,
that's not something the court's going to consider.
No,
but I mean, that's a big part of the story of these lawsuits.
It's a huge part of the story, but you also have to remember when you're going to file a lawsuit, like, why is this happening? So anyway, that's a great case, obviously very timely, and it gives us a lot to think about. So what's our homework?
Your homework is to go on the social media thingies and the YouTube thingy to find Chalk and Gavel wherever you get your podcasts.
And don't use AI to try to rewrite history. Oh, you like that?
Oh, that's good. Oh, that's sorry. Ooh, actually, no.
I should have used that earlier.
You should have. That feels a little Orwellian.
Well, right.
Yeah. He's just front of mind recently. But go check out Chalk and Gavel wherever you get your podcasts. Like, rate, review, subscribe. We would love it if you became a friend of the show on Patreon. And then you can find us on social media at Chalk and Gavel. We'd love to hear from you and keep the conversation going.
All right. That's it for now. We'll see you again in 2 weeks, everybody. Have a good one.